Picture this. It's a Tuesday afternoon. You're working from home, maybe on an important call, or just trying to get through your day. And then you hear it. Keys in your front door lock. The door swings open, and there's your landlord, standing in your living room. No call, no text, no warning, just there. How would that make you feel? Angry? Violated? Confused about whether they even had the right to do that? Well, in most cases, they did not have the right. And if this has happened to you, or if you're worried it could happen to you, you need to watch this video all the way through. Because today on Unlock Your Rights, we are breaking down everything you need to know about landlord entry, what the law says, what your rights are, what exceptions exist, and exactly what to do if your landlord thinks they can walk into your home like it belongs to them. Spoiler, it does belong to them, but your right to privacy does not. Let's start with the foundation. In the United States, landlord-tenant law is governed at the state level. There is no single national law that covers every situation. And here is something most tenants don't realize. Not every state has a specific law that sets an exact notice period. But here's what is true everywhere. Every state recognizes your right to what the law calls quiet enjoyment of your home. Whether that protection comes from a written statute, from your lease, or from court precedent, it exists in some form in all 50 states. Quiet enjoyment does not mean silence. It is a legal term. It means you have the right to live in your rented home, peacefully, without your landlord interfering, entering without permission, or disrupting your daily life. That right is yours from the moment your lease begins, and it lasts until the day you move out. Now let's look at how this actually works. Because it falls into two groups of states. Group 1. States with a specific entry law. Many states have written statutes that spell out exactly how much notice a landlord must give. Let me give you the confirmed ones. In California, the law requires 24 hours written notice before entry. This is Civil Code Section 1954. Entry must happen during normal business hours. And importantly, your lease cannot waive this right, even if your lease says otherwise. State law wins. In Florida, the law requires at least 24 hours notice before entering for repairs, and entry must happen between 7:30 in the morning and 8 at night. That's Florida Statute 83.533. In Washington State, landlords must give at least 2 days written notice for most entry and at least 1 day notice when showing the unit to a prospective tenant or buyer. And Washington even lets you collect up to $100 per violation in small claims court. These are real, written, enforceable laws. If you live in a state like these, you have a clear legal standard to point to. Now, Group 2. And this is the part most videos get wrong. Some states do not have a specific statute setting a notice period at all. Take Texas. There is no Texas state law that says a landlord must give 24 hours notice, or any specific notice. In Texas, your protection comes primarily from your lease. Whatever your lease says about entry, that is the controlling rule. And on top of that, Texas courts recognize your right to quiet enjoyment as an implied part of every lease. Or take Illinois. There is no statewide Illinois law on landlord entry either. Your protection comes from your lease, from the common law right to quiet enjoyment, and from any local ordinance. For example, the city of Chicago has its own tenant ordinance with specific entry rules, even though the state does not. So if you live in a state without a specific statute, here is what you do. First, read your lease carefully. The entry rules in your lease are legally binding on both you and your landlord. Second, Check whether your city or county has a local tenant ordinance, because many do, and they often fill the gap the state leaves. Even in states with no statute and a silent lease, courts still generally expect a landlord to give reasonable notice and to act in good faith. A landlord who repeatedly barges in unannounced can still be violating your right to quiet enjoyment, no matter what state you're in. So the bottom line is this: whether you're protected by a written statute, your lease, or court precedent, you are not without protection. You just need to know which one applies to you. Now let's talk about the exceptions. The situations where a landlord can enter, even on short notice or no notice. Exception 1, genuine emergency. If there is a fire, a burst pipe flooding the unit, a gas leak, or any situation that poses an immediate threat to life or property, your landlord can enter without notice. This is reasonable, this is expected, and frankly, in a real emergency, you want them to be able to get in. This exception exists in every state. Exception 2, repairs and maintenance you requested. If you submitted a maintenance request, your landlord or their contractor may enter at the agreed time. The key word is agreed. They still cannot just show up whenever they feel like it. Exception 3, scheduled inspections or showings with proper notice. A landlord may inspect the property or show it to prospective tenants or buyers, but only after giving you the notice your state or lease requires. Exception 4, abandonment. If your landlord has genuine reason to believe you've abandoned the property, they may be permitted to enter. But this is a high bar. Unpaid rent alone is usually not enough. Outside of these situations, there is no valid reason for your landlord to enter your home without proper notice and consent. Period. Here's where it gets really important, and where many tenants get confused. What if your lease says the landlord can enter at any time? Read this carefully. In states with a specific entry statute, like California, that clause is very likely unenforceable. State law overrides the lease, and you cannot legally sign away a right the statute gives you. In states without a statute, like Texas, the lease has more power, because the lease is the main rule. But even then, a clause allowing unlimited, unannounced entry can still be challenged as a violation of your right to quiet enjoyment. So the lesson is, never just assume a scary-sounding lease clause is enforceable. Know whether your state has a statute, and know your right to quiet enjoyment either way. Now let's talk about something most videos never: retaliation. What happens if you complain about unauthorized entry and your landlord responds by raising your rent, threatening eviction, or making your life difficult? That is called landlord retaliation, and in many states, it is illegal. In New York, for example, if a tenant files a complaint or asserts their rights, and the landlord then tries to raise rent or evict, the law presumes that action is retaliatory. The burden falls on the landlord to prove it wasn't. Washington State has similar protections written directly into its Landlord-Tenant Act, so don't be afraid to assert your rights. In many states, the law specifically protects you for doing so. Now let's answer some of the most common questions tenants ask. Question 1. Does my landlord need to give notice even if I'm not home? In states with a notice law, yes. Your right to privacy applies to the PRO, census quiet speed, not just to whether you happen to be physically present. Question 2. My landlord has a key. Doesn't that mean they can use it whenever they want? No. Owning a key gives a landlord physical access. It does not give them legal permission to enter without proper notice. Those are two completely different things. Question 3. Can I change my locks for privacy? In many states you can, but you may be required to give your landlord a copy of the new key. Check your specific state and city rules first. In Texas, for example, changing locks without permission can violate your lease. All right. Now, the most important section: what you actually do if your landlord has violated your privacy. Step 1. Document everything immediately. Write down the date, the exact time, what happened, who was present. Save every text. Save every email. If anything was disturbed, photograph it. Date-stamped phone photos are legitimate evidence. Step 2. Send a formal written notice to your landlord. State your name and the property address. State the date and time of the unauthorized entry. State that you are aware of your right to quiet enjoyment and proper notice. State the notice you expect going forward, and state that continued violations will lead you to pursue your legal remedies. Send it by email for a timestamp or by certified mail for proof of delivery. Keep a copy. This is now part of your legal record. Step 3. Escalate if it continues. File a complaint with your local housing authority or tenant rights office. Contact a local legal aid organization. Many offer free advice. And in states like Washington, you can sue for a set penalty per violation in small claims court. Step 4. Know your nuclear option. In cases of severe or repeated unauthorized entry, you may have grounds for a constructive eviction claim. This means the landlord's behavior has made the home effectively unlivable, and you may be able to break your lease without penalty and recover damages. Let me quickly recap. Your right to quiet enjoyment exists in every state through statute, your lease, or court precedent. Some states like California, Florida, and Washington have specific notice laws. Others like Texas and Illinois rely on your lease and local ordinances. The only valid exceptions are genuine emergencies, repairs you requested, scheduled inspections with notice, and suspected abandonment. And if your rights are violated, document everything, send written notice, escalate, and know your remedies. Above all, know that your right to the peaceful enjoyment of your home is real, it is protected, and it is yours. One final and important note. The information in this video is for general educational purposes only. It is not legal advice. Landlord-tenant laws vary significantly from state to state and even from city to city, and your specific situation may have unique factors. If you are facing a serious landlord dispute, please consult a licensed attorney in your state or reach out to a local tenant rights organization. Many offer free or low-cost consultations. Know your rights, seek proper guidance, and never let anyone, including your landlord, make you feel like you have none. If this video helped you, please share it with a friend or family member who rents. Subscribe to unlock your rights for a new legal explainer every week, in plain language, no law degree required. See you in the next one.